look at this piece of legislation. There's no doubt we're going to have to pass this today, because if we don't, we leave the 1,000 or so people still in wardship in legal limbo. But I think it's really unfortunate that it's been left to the last minute. I mean, the department or your predecessor must have foreseen that this issue would arise, because we've only slightly more than a quarter of people who were in wardship when this Act commenced 3 years ago. Actually discharged from wardship at this stage. So there's obviously problems within the system that, as I said, had to be foreseen. And had this been brought earlier, a year ago or even 6 months ago, we could have had a much wider debate about addressing some of the issues about what is causing the backlog. Because if we don't address the issues that are causing the backlog, we're going to end up back here again in another year or 18 months. And we can't have that. And I mean, the issues that are causing the backlog, I mean, seems to be that, there's difficulties engaging legal representatives with the appropriate skills and knowledge of support in the discharge world, and that's been referenced by our previous speakers here. So we need to look at that, and we need to properly resource the Free Legal Aid Board. We need to properly resource the National Advocacy Service and the actual Decision Support Service as well. They all have a part to play in this, and I don't think they've been adequately resourced to address the number of people who are still as wards of court or in wardship. I'm also concerned that this is not compliant with the UNCRPD. You're aware, Minister, that nothing about us without us is a mantra for that convention. And we have people here, many with intellectual disabilities, who are in wardship, but what I read from this is that they are notified of the discharge process, but they're not actually taken through it. They're not explained. And that needs to be done. That there needs to be information in accessible format for them and their families to ensure that they understand as much as possible the process, and that there's a fair way of addressing and assessing the capacity then, and then putting the appropriate supports in place after that. I'm also concerned about how this treats children in wardship. So if a child in wardship is due to exit that at the age of 18, are they going to be delayed for up to 18 months exiting wardship? And if so, then they could be 19 and a half before they get out. It's a really important time of life for many young people at that age, where they're looking at how their life is going to progress. Are they going to engage in further education or employment or whatever it might be? And that can be delayed because they do not have the right to make those decisions for themselves. So I think there's a number of issues here that it's unfortunate that it wasn't addressed in a more timely fashion, and the actual amendment bill broadened to discuss much more of the issues that are involved here. I mean, amendments have been ruled out of order. Those amendments are all vitally important to addressing this issue. And the same happened, I think, in the Dáil and when it was before the Disability Matters Committee, where amendments weren't approved and weren't discussed because they didn't fit within the narrow confines of the Act, so I mean, or of the bill. So it's important that we address the issues that are causing the backlog, so that we can have a fair system to ensure that people are properly informed, have the information, have the support to exit the wardship and be able to make the decisions for themselves. Thank you, Minister.